Thank you. Oh, it's 2:30, so I'm loading. Okay. And then one other thing, let me report to the club. Okay, we're good. You can start.
Okay. Hello, my name is Monica Harrington, and I'm an intake attorney here at the Legal Aid Helpline Central Intake Unit. And I'm going to be presenting today on tenants' rights for our tenants' rights clinic. And I would like to start off by just saying we prefer that you use the question and answer feature over the chat feature. You can use either, but it's easier to monitor the question and answer. And so to keep things uniform, that would be best. And I will answer and go through and answer the questions and answers at the end of the presentation. So I'll do a run through the presentation and then address those questions and concerns. I'd like to also let you know that I am not here providing legal advice. I am simply making a presentation, informing you of, the law and such. And so if I would advise against sharing any personal information. If you would like assistance with a specific case, then you can call the helpline. And so I just wanted to make that disclaimer from the beginning so that you don't divulge any information that you shouldn't be. And if you do, I'm unable to address it in specifics. So keep it as general as possible. So Legal Aid of North Carolina is a statewide nonprofit firm. We provide free legal services to in civil matters, not criminal, to low-income people in order to ensure equal access to justice and remove legal barriers to economic opportunity. As you can see, our areas of practice include housing, which this is a housing presentation today, employment, education, domestic violence, disaster relief, and consumer issues. And we provide monthly clinics like this one for child custody and visitation, employee rights, healthcare power of attorney and living wills, simple divorce, social security disability, and tenants' rights, which today I am doing tenants' rights presentation for the clinic. Below you can see our email. It is legalaidnc.org, and the helpline that you're going to want to call into if you would like to seek legal assistance is 1-866-219-5262. And you can write those down, or at the end of the presentation, I'll also have them again available to you. Or if later on you want to just type in a quick Google search, you should be able to find that information. So to begin, an overview of the eviction process. So the eviction process in North Carolina is called summary judgment. And the only way a landlord can legally evict a tenant in this state is by filing a lawsuit and getting a court order for the eviction. They cannot do what we call self-help measures, where they may, attempt to lock you out or prohibit your entry in some sort of way into the home. Well, if they haven't resorted to the legal process, and if they haven't obtained a judgment from the court, and permitting them to legally lock you out, then that is illegal activity in the state. And so the summary judgment process, the eviction process, applies only to landlords and tenants. And sometimes people in hotels can be considered tenants. It depends. You would want to analyze a number of factors in a situation where it is a hotel stay situation. And the landlord can serve. So the landlord will serve. They'll file the eviction at the clerk. They will serve the court papers by either emailing the court papers to the tenant, or by delivering via the sheriff or posting on the tenant's door the eviction papers. Personal service isn't required. Usually the cases are, the eviction hearings are heard in the small claims court in front of a magistrate within 7 days of the landlord filing the eviction. And so it's a pretty quick, expedited process as far as the summary ejectment process goes. Now, I see there's a note here about COVID, although I don't think that's any more relevant. However, if you're concerned in any way, give your county clerk a call and they should be able to answer any questions about hours, operation or otherwise. Again, this slide is not really pertinent anymore because courts, to my understanding, are open normal hours. However, like I said, you can call the clerk and inquire about that if you desire. Before trial or before the eviction hearing, tenants, so the court paper consists of 2 documents. First one is the magistrate summons, and that tells the tenant when and where the eviction hearing is going to take place. It'll tell you, including the court number, the location of the court, what time. And the second is the complaint and summary ejectment, which is just the eviction document telling you what the landlord's basis for the eviction is. And so you can read the complaint to gather more information on, okay, why is my landlord evicting me? What are they alleging as a basis? And sometimes they don't check a box for the basis, and in which case, you might want to be prepared for potentially different basis if you're unable from the circumstances to identify which one it might be. But that complaint is going to help you to prepare a defense. This is what it looks like. They're available at the clerk. This is one of the second paper you'll be receiving in your eviction paperwork, and where, if you look, the box numbered number 3 with the 4 little boxes in it, that is where the landlord is going to state the reason or reasons for the eviction. With respect to the trial, to the hearing itself, it's important to be on time, early if possible, 5 to 10 to 15 minutes just to, in case you can't find the courtroom or something like that. Note on face masks. I guess it would depend, perhaps if your city or county is requiring masks. That's something you can ask the clerk about if you're concerned. But my understanding is many of them don't require masks anymore. Magistrates are the arbiters. They preside over the eviction hearings. And as noted here, they don't have a lot of courtroom assistants. So they appreciate well-organized presentations, being prepared. And if you're a tenant who has evidence, pictures, text messages, documents, you should print them out. Some counties do not permit electronic evidence. And so if you're trying to admit something by showing the magistrate on your phone, well, that might be unacceptable. I know in certain counties like Mecklenburg, oftentimes on the complaint, they will say, have a stamp that says, photo or photo not printed out, evidence is not permissible, is not acceptable. And so you're going to want to print everything out that you plan to bring to court and bring 3 copies if possible, so that you have one for the tenant, the landlord, and the magistrate. So yourself, your landlord, and the magistrate. So everybody can be looking at the same thing at the same time. It makes it a lot smoother and easier and quicker. You can bring witnesses to provide testimony that you think might be helpful to your case. The landlord can do the same. You can object to what we call hearsay. And basically hearsay is where your landlord is trying to testify to something that they don't have personal knowledge of, firsthand knowledge. So a quick example of hearsay would be if if you're in court and the landlord is testifying to what their employee or agent or another party that is not the landlord, him or herself, said, and that's objectionable. You can say objection, hearsay, because hearsay is not supposed to be permitted to be, the basis of evidence that ultimately the magistrate will consider in making their decision. And it's best to end by telling the magistrate what you want them to do. So if you want them to dismiss the case, then you can say that in a sentence at the end. And magistrates typically rule immediately after they have heard from all the parties and all the evidence has been presented, although they can reserve judgment, say if they need to research a complex legal issue or something, and can take 5 business days. So after the trial, if you lose, you can appeal for a new trial, a new hearing in district court, a different setting, not the small claims court, in front of a judge instead of a magistrate. Magistrates may or may not be attorneys. All judges are attorneys within 10 calendar days after the judgment. So if you had your hearing on Friday, or let's say if you had your hearing on, the 10th, then 10 days after that day, that is your appeal period. And you need to file certain documents with the clerk if you want to appeal. So if you've lost, you want a new hearing and you want to appeal, you need to file a notice of appeal. The clerk should have all of the documents, but they're not able to help you fill those out. And so if you reach out to legal aid does have some guidance on how to fill those out. You can prepare a bond to stay the execution of the summary ejectment judgment form. And basically that is related to if you wanted to remain in the home during the pendency of your appeal. And so if you want to do that, if you want to appeal and you want to try to stay in the home during that time, you have to pay your rent into the court as a bond as it becomes due. Indigent tenants, so tenants who are unable to pay for the cost of the appeal, which is about $150 to file an appeal. And also when you appeal from a non-payment eviction, you normally have to pay the arrears as determined by the magistrate, the arrears being the back owed rent. But if you are able to proceed as an indigent, which is going to be a separate form called a petition to proceed as an indigent, and you're able to qualify for that, then you can they will waive the filing fee and you will not be required to pay the arrears in order to appeal. And so with the indigency form, you qualify for, automatically if you receive food stamps, if you receive SSI, or if you are in a program, TAMF, Temporary Assistance for Needy Families, or if you are represented by legal services organization like Legal Aid, or there's a catch-all where none of those apply, but nonetheless you're unable to put forth the money. And so my understanding is if you're going to try to qualify for the catch-all, you might have to fill out some paperwork with financial information, income and such, and the clerk will determine whether you meet the indigency standards. If you don't appeal and pay the bond within the 10-day period, then your landlord can get a writ of possession for the property, which is the writ enables them to have the sheriff lock you out of your property on the 11th day after the judgment. So you're safe in the home for those 10 days, no matter what. But if you don't appeal by that date, or if you don't pay your rent bond, then that subjects you to being locked out by the writ that I mentioned. So, okay, the first basis, there are 4 different boxes that the landlord can check as grounds for an eviction in North Carolina. The first is failure to pay rent. We call it statutory non-payment of rent. And it is basically an implied forfeiture if the tenant fails to pay all past due rent within 10 days. I apologize. 10 days after the landlord makes a demand. So basically what this means is this is used only for verbal leases or leases without certain default or forfeiture provisions. And so where the lease doesn't contain that, or it's a verbal lease, what the landlord has to do is make a clear demand for all past due rent. A proper demand includes also notifying the tenant that the landlord intends to exercise their forfeiture rights or file an eviction if you don't pay the rent. And so within that 10-day period, the landlord can't file the eviction. So they have to make the proper demand, wait 10 days, and then if you've not paid up what is required, then they can file the eviction. And as a possible defense to this type of eviction, we call it tender. And so tender is synonymous with offer. And if they file an eviction against you and you have the money to be able to put forth, which includes the court costs, which now are $126, 96, I believe, for the filing, and then 30 for each defendant served. If you can pay all of that at the hearing, then you can get the eviction dismissed. So that is a defense to this type of eviction. The second type of ground for eviction is what we call holdover. And basically at the end of the term, your landlord can elect to not renew your lease or terminate your lease, really for any legal reason, any reason that's legal. If you're in a year-long term, that can't happen until the end of the year. If you are in a month-to-month term, meaning you're a month-to-month tenant, that can happen at the end of the term, which is a month. And so can happen a lot quicker with a month-to-month tenancy. But the landlord, before they can terminate the lease and file an eviction for holdover, has to give sufficient notice. And the notice has to be proper in order to terminate the lease, because if the lease is not terminated properly and then you're still there past the date that the landlord said to be out, that your lease was over, and they file an eviction for holdover, well, if they didn't terminate properly, then that can be an argument against this type of eviction. So if you're a month-to-month tenant, the default under the law is you have to provide 7 days notice, at a minimum of 7 days notice. So, at 7 days before the end of the month, your landlord would have to give you notice, hey, I am not renewing your lease, I'm terminating your lease, and it has to be terminated at the end of the period, which at the end of the month would be whatever the last day of the month is. But some leases, now if the lease has a different provision on providing notice, then that's going to govern. Some leases would have a provision where you need to give 30 days notice, even if it's a month-to-month tenancy. And so if that's the case, then the landlord has to give 30 days notice. And if they don't, well, then that's not going to be a proper notice. And they would hopefully not be able to successfully evict you for holding over past that date. And as I said, the notice has to terminate the lease at the end of the period, which for the month is the last day of the month. So if they try to terminate in the middle of the month, that's not going to be proper. And for week-to-week tenancies, 2 days notice is the minimum requirement. And for a year-long terms, it's 30 days is the minimum. But like I said, the lease can provide for more, not for less notice, but more. And if the landlord accepts rent after the end of the lease, after the date by which they said your lease was going to be terminated, well, or if you sign a new lease, that creates a new tenancy. And so if they wanted to terminate based off that original notice, it wouldn't be effective. They'd have to issue a new notice at that point. All right, the third basis is violation of lease term or breach of the lease or breach of a condition in the lease. First, in order for it to be a breach of the lease or a violation of the lease, it's got to be a condition that's contained in the lease, right? So a landlord can't say, hey, you breached the lease because you had a dog. Well, if the lease doesn't say you can't have a dog, then you can argue, well, that's not actually a breach of the lease because it's not a condition in the lease. And the lease, so most non-payment cases are brought as breaches of the lease. The first non-payment that I mentioned about the statutory non-payment, that is where the lease doesn't permit for forfeiture upon breach. So if your lease contains provisions where, okay, you need to pay rent in this amount by this, on this day, if you don't, then, we can terminate your lease or terminate your possession or otherwise, forfeit, then this would be the proper way to bring a non-payment of rent case as a breach of the lease. And so most non-payment of rent cases are brought this way because the leases do have those provisions. Leases can waive notice, but some leases still require notice with respect to the breaches. Okay, you breached, we're gonna, have to notify you that you breached and possibly give you the right to cure. It depends on the lease. And also most tenants and subsidy programs like public housing or Section 8 housing choice voucher or project-based Section 8 are entitled to notice through those, housing and urban development sort of procedures. And also on the complaint, there is a box between paragraph 3 and 4 where where you're supposed to describe the breach. So if it's non-payment of rent, you would say failure to pay rent. If it's having a dog when you weren't supposed to have a dog, it'd be something along those lines. Now, lastly, the last basis for an eviction is criminal activity. This is very specific type of criminal activity. So it covers violations of the North Carolina Controlled Substances Act, or also other criminal activity that threatens the health, safety, or right of peaceful enjoyment by other residents. That's, that with that put in there, it covers a little bit more broad type of activity. And the Controlled Substances Act allows a partial eviction of an offending household member. So, it's a household, but only one was the one actually committing the criminal activity. Allows conditional eviction involving culpable guests or household members whom the court does not have personal jurisdiction over for whatever reason. It permits affirmative defenses. So, if you face an eviction for criminal activity, it's marked that fourth box. And, you think you might have an affirmative defense. Well, if you didn't know or have reason to know that the criminal activity was occurring or would likely occur, that might be an affirmative defense. And the tenant if you'd done everything as a tenant that could reasonably be expected under the circumstances to prevent the commission of the criminal activity. And a lot of the criminal activity involved has to do with drugs. Although it as far as includes a catch-all serious injustice defense, which is a high standard to meet. Okay, so those are the grounds for eviction in a nutshell. Now we're moving on to the implied warranty of habitability, which is something that's very common. And this can be, so the landlord has a duty, to keep your place in a fit and habitable condition. And so a violation of this can be a defense against a claim based on unpaid rent, so non-payment of rent. And it can be an affirmative claim as well, that you bring, unrelated to other claims that you would bring on your own. File it with the clerk of court as an affirmative claim is what that means. Now, the law that governs this is North Carolina General Statute 4242. And landlords are obligated under the law to keep the premises in a fit and habitable condition, obey local housing codes, repair imminently dangerous conditions in a reasonable amount of time based on the severity of the issue. And the imminently dangerous is defined by the statute. And so if you're, it's not just, oh, well, I think this is imminently dangerous. Well, is it defined in the statute? And so, you can refer to the statute to be sure. Keeping common areas safe. They're obligated to keep electrical, plumbing, sanitary, heating, air conditioning, and other facilities and appliances supplied by them in good and safe working order. So if your landlord supplied an air conditioner, which they're not obligated to supply it, but if they do supply it, then they are required to keep it in working order. And so that's something, that is probably pretty common out there. An air conditioner that's not working that was supplied. And so, you would be able to hold the landlord to that obligation of fixing that if they supplied it. Installing smoke detectors and carbon dioxide detectors. And this 4242 also addresses that the landlord can't waive these duties or avoid them. So if the lease says, I'm not required to provide a fit and habitable place, well, you can't, that's not permissible. And so if your lease contains a provision like that, that's not enforceable. They're required to do this no matter what. A little bit more on this. So you can bring what's called a rent abatement claim. And that is what that's what I'm talking about with respect to the affirmative claim, or bringing it as a counterclaim to, a non-payment of rent case eviction. So the rent abatement action is a tenant essentially asking for a rebate of their rent. So they have to have paid, you have to have paid rent in order to seek a rent abatement, because it's at the end of the day saying, I want some of my money back. And the money that you would be asking back is on this first bullet, the difference between the fair market rental value as warranted, meaning, everything up to code and in fit, habitable, good condition. And the value of the home in its defective condition as a result of the landlord's, failure to uphold their obligations to repair and things. And so that difference is what you would be requesting in a rent abatement claim. The damage, that money that you're requesting is limited to the amount of rent you actually paid. You can't ask for more than you actually paid, because again, if you think of it as an abatement or a rebate, you have to have paid in order to get the money back. And you can also ask for, in a rent abatement claim, consequential damages, which are often incurred. So for example, your heat went out in the thick of winter, and despite reporting to your landlord, verbally and writing, putting them on notice that, your heat went out that they had provided to you, and they didn't do anything about it. You had to buy a space heater on your own. That's something, assuming you save the receipt and you're able to prove it, that you can ask for money back for that as well. Or other examples, increased heating costs, or motel stays because your place is rendered uninhabitable for whatever reason. A bit more. So Typical evidence that you'd be able to, when you bring a rent abatement claim, whether it's a counterclaim against an eviction or whether it's an affirmative claim, you're going to have evidence, right, to prove your case. And so typical evidence consists of code inspections, complaint and notice of hearing, and finding of fact and order. So this is where you are having issues despite reporting to the landlord properly, they don't do anything about it. You call the city to see if code enforcement is able to come out and do an inspection. And they will normally generate a report. And so if there are violations that they've cited, you can use that as evidence, bring it in. If you have text, emails, or just simply testimony for requests for repairs to the landlord to show, because this is important because you first, before the landlord has an obligation to repair, they have to be notified of the defects, of the problems that need repairing. And so it's always best to do this in writing and keep proof so that down the line, if there's a dispute, you have that proof to be able to show. Versus just testifying to say, well, I told him on this date. It's just stronger evidence. Pictures of the defects or anything related. The local housing code. So if your area has a local housing code and you're trying to bring this type of claim, you got to introduce it as an exhibit. And so you can find that online, and just bring it in and introduce it as an exhibit. And also you know, provide testimony about the conditions and how they impacted your family, you or your family or whomever's living there, and the value of the home too. So you have to testify to, you can give your opinion of what you think the value of the home was in its defective condition. And then, you know, then you take the difference between what you estimate the diminished value to be between what, you know, the house is worth in its good condition, and that would be what you're asking for as far as money back. Unfair and deceptive trade practice. So one case, Creekside Apartments versus Poteat, says that collecting full rent, so when a landlord collects full rent from you, you know, your full rental payment, while refusing to make repairs, well, that can be an unfair and deceptive trade practice. And so if a tenant files a counterclaim for rent abatement for the implied warranty of habitability, then you might also consider bringing this type of counterclaim, unfair and deceptive trade act. If your landlord, you know, was demanding full rent and collecting full rent, all while refusing to make repairs that needed to be made. And if granted any damages on this, you can triple the damages and attorney's fees potentially. With respect to kind of another type of claim, a unfair debt collection claim, landlords cannot misrepresent the amount or nature of a debt in a legal proceeding. So if, you know, on the complaint, the eviction document, they claim you owe, you know, all these different fees and all this different rent, when really, you know, it turns out you don't, then you can raise a unfair debt collection claim, counterclaim in that eviction proceeding. If, you know, you can prove, hey, I didn't actually owe this, you know, maybe through a ledger showing you were caught up and they're saying you owe $2,000, or a lease saying that, you know, a lease not providing for certain fees to be charged and your landlord charging all these fees, just kind of pulling it out of thin air. Also, landlords cannot collect or attempt to collect fees or charges that are not due. So the North Carolina General Statute 7550 kind of governs these unfair debt collection claims. And so, look, kind of like I said, if they're trying to collect fees or charges that aren't actually due, or that they're not even permitted to collect in the first place because the lease doesn't say so, then that can be an unfair debt collection. And a landlord who commits these types of violations is liable to the tenant for actual damages, meaning, you know, the damages you actually incurred if you accidentally paid, if you paid, you know, the 2,000 that they were saying you owed when in reality you didn't know it. But also civil penalties of at least a minimum of $500, but no more than $4,000 for each violation. And so the prevailing understanding appears to be that that is a permissive, the civil penalties are permissive as far as awarding them if, you know, if a magistrate or a judge determines that there has been a violation of this. And so, you know, these are pretty serious claims to pretty serious violations. And so some common debt collection violations, things like improper late fees, maybe like they're charging numerous when you're only permitted to charge one for each period. Or maybe they're charging beyond what's permitted, which is $15, a minimum of $15 or 5% of the rent, whatever's greater they can charge. An excessive utility admin fee, month-to-month fees that aren't provided for, court costs that they're not entitled to collect, different rounding errors, certain things like that, increases in rent that, you know, aren't permitted. So anytime they basically represent that you owe something that you don't actually owe. Other common defenses to evictions, kind of just generally, retaliatory eviction defense is in a nutshell where you've taken, it's in chapter 42, and it's basically where you as a tenant have taken protected action, whether it be reporting repairs to the landlord, calling the city, you know, to do an inspection, things like that, joining a tenant's rights organization. There are 5 that are provided for in the statute, 5 protected actions. And so for retaliatory eviction defense, where you think that your landlord filed an eviction substantially in response to you taking one of those actions, well, you can raise this defense. Now, if your landlord is able to counter with, well, no, I brought this non-payment of rent defense or eviction because they didn't pay rent, they might be able to defeat your retaliatory eviction defense. But it's something to think about. If you're a victim of domestic violence victims have extra protections. And so if you are, you know, be aware of that. Waiver, so addressed this a little bit earlier, but something like if your landlord files a breach of the lease for having a dog or anything else, even if it was in fact a breach, if after the fact they accepted rent, then that is a waiver of the breach unless there's a valid anti-waiver provision in the lease, which I've seen a lot of leases do have that. So now accepting rent is not a waiver regarding criminal activity unless it's the basis of a breach of lease rather than criminal activity. So other defenses, invalid notice. So this speaks to mostly the holdover eviction. You know, if they didn't do it properly, if they didn't try to terminate the lease at the end of the month, if you're month to month, if they did it in the middle of the month, that's a possible argument defense. If they didn't give you the proper time that they're supposed to under the law or under the lease, that's a possible defense. A failure to offer reasonable accommodation, and a reasonable accommodation is federal law. There are multiple federal laws that protect people with disabilities, and so that's related to persons with disabilities. And a reasonable accommodation, more or less, is a tenant wanting to enjoy, you know, the housing in the way that everyone, who doesn't have a disability does. And so because of that, they might be requesting maybe a modification in their home, like a peephole if they're in a wheelchair that is down lower so that they can access it, maybe grab bars if their mobility, if their disability, affects their mobility, or it can be like a request for an exception or a change in a policy based on someone's disability. There's got to be a nexus between the request you're making and the disability. Another common defense, the amount of whatever rent fees that they're claiming is not accurate. So that's something else that you can point out and say, well, Your Honor, they're saying I owe this. That's not right. I have my ledger right here, something like that. Or failure to make a demand for possession before filing the lawsuit. Where the landlord fails to demand possession after or before filing certain evictions, that's a possible argument. I don't know how successful it is in most places, but it's the understanding is that they also have to do that. So meaning make a demand for possession of the home before they file the eviction and after maybe the breach has occurred, if it's a breach of lease case. So execution upon a court judgment. Court judgment is just the judge's decision, magistrate or judge's decision, which in the case of small claims eviction hearing, it's going to be a magistrate. And once the judgment is final, which the judgment becomes final, remember, if you don't appeal within the 10-day period, then it becomes final. Or if you don't keep current with your rent bond obligation, then it becomes final, because your rent bond is staying the execution of the judgment below. And so if you're not paying your rent bond, then what happens is that stay is removed. And your landlord, so if you don't keep current with a bond or the judgment is final, your landlord can and likely will get a writ of possession from the clerk, where, like I mentioned earlier, that goes to the sheriff and directs the sheriff to execute it, which the execution of the writ is to lock the premises and make sure that all tenants are out of there. And so the writ is normally executed or has to be executed within 5 days of the sheriff receiving it. And you'll get notice when the writ's going to be executed. And so, it's best to kind of, if you knew that you didn't pay the rent bond and, your case was on appeal, you became unable to pay it, just this is something that you're going to want to keep an eye out for. In which case you have to leave the home at that point and find another place to live. And so once the locks are placed on the door, depending on the value of the remaining property, so it's best to try to get, once the writ's been issued and you got notice of when it's going to be executed, it's best to try to get all the important things out first. And then once the locks are placed on the door, you have to leave. If you try to go back without the consent of the landlord, you could be arrested for trespassing. And after that point, when the locks are placed on the door, you either have 5 days or 7 days to get your remaining property out. Now, it's 5 days if the value of the possessions left in the home are less than $500. It's 7 days if it's more than $400 for the things you still have left in the home. And it's on you to coordinate with the landlord to reach out to the landlord to get your remaining possessions out of the home at that point. They are under the law obligated to provide you at least one opportunity to go back and get your stuff. Normally during regular business hours, but if you coordinate something else, then that's fine as well. If there's any trouble with that, I imagine contacting the sheriff You know, if your landlord is not permitting you to go back in within that time frame, then contacting the sheriff is probably your best bet. The sheriff will, okay, so already covered all that. Okay, so jump the gun a bit. So this is 7 days, but it depends on the value of the remaining possessions in the home. And like I said, they have to, they can't require any payment or anything to remove your stuff from the home. But if after the 5 or 7 days, depending which one applies to you, you still have stuff remaining there, the landlord can dispose of it as they wish. They can throw it away, they can sell it. So, you know, if you have important things in the home that you want, it's on you to get them out within that time frame. The security deposits, so, you know, you pay your security deposit when you move in. And then at the end, your landlord has 30 days after you vacate to return the security deposit to you or to itemize any deductions, meaning, you know, if they're retaining some of the security deposit for damage beyond normal wear and tear, then they have to show you kind of an accounting of how they're using it, what they're using it for. So either that or return it in full or in part 30 days after you vacate. If the lease fails to identify the bank where the security deposit is held, then you're entitled as the tenant to a return of all the deposit, regardless of the property's condition. So you might want to check your lease if it comes to the point where you're planning on vacating and want that security deposit back. Also, it's best practice to document the property's condition when you vacate. So if your landlord tries to claim all this damage, but you have proof that that damage didn't exist when you vacated, then it's going to be really important to have. So that's the end of the presentation. Again, here is the legal aid helpline information. You can apply by calling this number or by doing an online application at that website. But also, if we're unable to assist, another resource is the lawyer referral line. And it looks like the first number is if you're in North Carolina, second is if you're outside of the state. And there, for $50, you get a 30-minute consultation with a private attorney. So say it's something legal aid ultimately is unable to assist you with, then you can call this helpline and see, you know, okay, for $50, I want to talk to a private attorney about my problem. So that's an option. Now I will go. Okay, so it doesn't appear that we have, doesn't appear there are any questions or chats. And so I'll just confirm that with Niall to be sure that I'm not missing something.
Yeah, I don't see anything.
Okay.
Give me
Okay.
1 second, I'll check Facebook.
Okay, thanks.
Here we go.
Okay.
Oh,
Oh,
it threw me back to the top. Okay. Oh, that's trippy. Okay. Okay, we got a
4.
couple questions.
Okay.
Okay, I don't know what this means,
Wait,
but
is this?
Deb
Okay.
Evans. Okay.
Okay, and Niall, and will there be a recording posted anywhere?
Yes, on Facebook.
Okay.
On Legal
on
Aid
Facebook.
NC Facebook.
Okay, so I see what would I do about pest control issues? So if this is something that, you know, you've reported to your landlord, and they've neglected to address the situation. Depending on, you have an option to call the city code enforcement to see if they can come out and conduct an inspection. And depending on what the city code says, though, if the code provides for the landlord to address or, for pest control issues to be the responsibility of the landlord, then obviously that's helpful to you. Now, where pest control issues perhaps are something that might be attributed to something the tenant is doing, something like as simple as leaving trash out or something like that, then the responsibility can be on the tenant. But if it is something like a structural problem, say maybe there is a crack in the foundation where there are pests coming through that way, or a hole in the floor or something, then that's something that it would be the responsibility of your landlord to address. If they're not addressing it, despite your reporting, and like I said, it's always best to report in writing so that and keep proof of it, then you can try to reach out to the city and see if the city is able to conduct an inspection and see, okay, what is the source of the pests? Is there something structurally wrong with this? And if you call the city and the city finds violations with respect to pests, structural problems, whatever type of violation of the code, then they will generate a report, and the report will have the violations they found. They'll give a copy to the landlord, a copy to you. There'll be a chance for a hearing, a notice of a hearing. And then ultimately, they'll give the landlord a time frame by which they need to make the required repairs, and they'll come back and do a reinspection. And if the problems still persist, or if it's, the landlord didn't fix the problems, and the landlord can start to incur fines. And so with issues like that, it's best to, number one, be sure you've reported it to your landlord in writing, give them a reasonable amount of time. But then, there's always an option to call the city code enforcement and see if they're able to conduct an inspection. Because if the source is something like a structural issue, then it's going to be your landlord's responsibility. Can previous tenants' testimonies be used in court? Yeah, you could bring, I don't think there's anything prohibiting it. Having previous tenants testify to, I imagine this, maybe in a situation where it's the condition of the home, and previous tenants had similar issues, then that is something that you could do. Now, you'd want to weigh, the kind of pros and cons to bringing in previous tenants to testify and ensure that, what they're going to testify to before, because they will be subject to cross-examination. And so consistency would be very important in a case like that. How long does it take to become an intake attorney? Well, it takes a while to become an attorney in the first place. You've got to, go to undergrad, and then law school is typically 3 years, although I know it can be different depending on if you're on an expedited track or if you're doing part-time, it can take longer. And then you got to take the bar and pass the bar, and then you can apply to be an intake attorney and maybe become one. Okay, so I see this one is kind of, providing more specific information, but I can address it in more of a general way. And I see that same person, the issues were there before they moved in and not remedied. So, if you're trying to establish a pattern that these issues existed, for other tenants and existed for you as well, then that is a possibility, and something you can consider, bringing in testimony from other, previous tenants, but, be sure to kind of vet what they would say, and of course, have it be truthful, and consistent with what you're wanting to prove. So, okay, a cockroach infestation and reporting, okay, so if you have a cockroach infestation and you've reported it, a lot of people report via resident portals and email and things, and that's fine. And, that's memorialized in writing, so that's good. Now, I think it depends, if your landlord has not responded at all, or if they've, refused to do anything about it, saying, hey, we're not, that's your issue, or whether it's something that, they're saying, okay, we'll get somebody out to look at it. Like I said, it kind of goes with the other question about what is considered a reasonable amount of time. Well, it depends on the defect. It depends on the issue. Reasonable, I think, would just be, there's not a real calculation. It's more probably of a bit of a subjective standard, nothing objective, like this is reasonable amount of time for any type of situation. So if it was an infestation, to ultimately resolve, might take a while. But if they're addressing it within, beginning to address it within a reasonable amount of time, like, okay, I reported an issue with an infestation to my landlord 1 week ago, and they've since not responded, and I reached back out and reported it the next week, and they've since not responded, or maybe said they were going to do something, and then now it's another week out and they haven't done anything. Well, that depending on the severity of the infestation, if it's cockroaches or otherwise, it would be something you would take into consideration, all the circumstances. So what is the severity of the problem? What might it take to resolve? If it's an air conditioner and it's the heat of summer, but your landlord is, they've taken steps and something's on back order. Okay, well, that's one thing. Maybe in the meantime, they'd be able to accommodate you with a window unit. But really, it's going to be subjective, the reasonable amount of time. You're going to have to take everything into consideration and make that sort of determination ultimately. But if it feels like it's been a reasonable amount of time and they haven't done anything, then you can either reach back out, or if that is futile, then you can try to reach out to the city, or, pursue one of those renovation actions, and try to recoup some of the money that you've been paying, because of the defect and because of their lack of making repairs. Okay, security deposit. Security deposit, financial institution not listed. What's the exact NC statute that states the deposit must be returned in full? So I can point you to the statute. Oh, I apologize. This is causing me. And I know my screen is being shared. I'm just pulling up the So the relevant law on this is going to be the Tenant Security Deposit Act, which is North Carolina General Statute starting with 4250. So if you just Google North Carolina General Statute or Tenant Security Deposit Act, it would state that. Now, with respect to that particular question, I can't say without actually reading through which provision speaks to what the question you're asking about, if they don't list the bank. So I apologize, but I can at least direct you to the statute. Okay, so okay, so oftentimes a lease might contain a late fee that exceeds what's permitted under the law. If they never charged it, I guess it's possible that they're representing that is something that would be owed. So, could that be the basis for an unfair debt collection practice claim? Possibly. I'm not certain, frankly. But if they were to charge it, then yes, certainly. But I think the representation is there. And so that's something to be considered. But if so a situation where a landlord takes some fees out of the security deposit, not fully understanding. Let's see here. So if your landlord is taking from the security deposit during the duration of your tenancy, while you're a tenant, that is not permissible. The security deposit is, they're permitted at the end of the tenancy to retain some of the money for damages, like I said, that are beyond normal wear and tear, or other prescribed uses, which are in that same Tenant Security Deposit Act. But that something like that does not sound permissible, where they're, okay, so now I'm seeing a development in the chats. Give me 1 sec. So if fees were charged, but then removed subsequently, you could probably still make an argument, if you had evidence, in a ledger or otherwise, that they were charged and collected, but then after the fact, refunded. Well, you might not have any actual damages as far as you got refunded all the money, but it appears that would be a basis for possibly unfair debt collection claim, because they did represent that you owed that those unlawful fees. They collected on them, but ultimately refunded them. And so I would imagine if you had the proof, you might still be able to bring such a claim. Now, whether you'd be successful is another thing. You said evidence should be printed. Does that mean we can't use videos? Good point. Videos are different. You can use videos. And so I would just, if you're going into the small claims court and you have a video, I would just bring it to the magistrate's attention and see how they would want to receive that. I know before, when I had been in court, I've shown videos, and so a video should be fine, but just discuss it with the magistrate. Now, in a courthouse where maybe cell phones are prohibited, which I've heard, that might be something you would want to call into the clerk of court and ask about. Okay, so from Facebook, no reason. Pay the rent. Okay, so I think I might. Niall, should I still be sharing my screen, or I don't know how to stop sharing?
What's happening?
Oh, should I stop sharing my screen at this point when I'm,
Yes, you can stop sharing.
okay, there we go. Okay. Let's see. So. Okay, it looks like on Facebook, we might have a couple comments, although we're not really able to determine what the question is, if there is one. So I just want to let you know that. Something about a reason for evicting disabled family, I believe, although it's not really a question, so I can't answer it. Something about paying rent on time for a number of years and passing all the HUD inspections. Not really a question there. And then, okay. And then what's an intake attorney? That's a good question.
Oh no, that was me.
Oh, okay. I was like, okay, well, I think we've answered all the questions then. Thanks everyone for coming. Niall, if I missed anything that you're saying, then let me know. But thank you all. I hope this has been helpful. And feel free to refer back to this clinic video or the others from my colleagues at any time. And like I said, if you have a civil eviction matter that you think legal aid might be able to assist with, you can call in or apply online and go from there. Thank you.
Cool. Thank you so much, Monica.
Okay.
Thank you
Thanks,
to
Tom.
everyone that joined, and have a great evening, everyone. And be mindful of the heat. It's hot out there. Bye bye,
Bye
everyone.
all.